Here with us this morning to deliver a special report from the Supreme Court of Georgia is the Honorable Chief Justice Harold Melton, a stranger to none of us. Chief Justice, thank you for joining us.
All right. Thank you, Daryl. Daryl, very moving comments and very appropriate remarks, so thank you. First of all, ladies and gentlemen, I long to be with you in person. It is great to be with you today, but a lot has happened since the last time I addressed you. You may recall that my remarks to you at that time at our last summer meeting were very brief, but a lot has happened since then, and I want to go in order of events and actually focus on the last 6 months. The new judicial building was dedicated in February, and we had the dedication service out front of the building. Governor Deal was there. Our keynote speaker was Associate Justice Clarence Thomas, and he challenged us during his remarks to remain disciplined and courageous. He predicted that we would face challenges in the future, and he challenged us to remain disciplined and courageous as we face those challenges. He must have known something. I'm so glad that Justice Robert Benham was able to be a part of that dedication ceremony just before he retired. He's doing well, he's enjoying retirement, and I know he would long to be with you today. You should know that he is doing well, and he knows how much he means to us, and we all know how much we mean to him. He was replaced by Judge Carla Wong McMillan, our now newest justice on our court, and she came to us with a wealth of judicial experience, having come to us from the Court of Appeals. As y'all know, she's the first Asian Pacific American to serve on the state's highest court here in Georgia or any other court in the southern United States. What's unique about her time with us is that 100% of her time with our court, both for her and her staff, has been remote. It's been virtual, 100%. So our court has definitely entered into a new phase, but we are glad to have her here. She's jumped right in and she is doing well. And then the pandemic hit, the coronavirus, COVID-19, whatever name you want to call it. And looking back, I am confident and proud to be able to say that we were more prepared going into this crisis than we knew. We were prepared for a couple of reasons, 3 to be exact. First, I want to take us back to 2007. In 2007, somewhere around there, the Chief Justice of the Supreme Court was Leah Sears, and she called me into her office. She called me into her office because some fellow by the name of Seth Kirschenbaum had approached her and said, you know, all the healthcare officials talk about a pandemic coming at some point. We don't know when, but it'll be coming, and it would be wise for our courts to begin preparing. And so he talked her into forming a task force, a committee, and then she asked me to chair that committee. She also gave me Michael Terry, who was a staunch advocate for the needs of the court system and the judiciary and the bar in the event of pandemic, and he was a very strong worker on our task force. I was not initially interested in that work because in my mind, I viewed it as the committee for the advancement of the preparation for the falling sky. But as we got into the work, I did realize that this was a real threat and that we needed to take it very seriously. One of the products of the commission was a bench book. This bench book provided model orders for local and statewide judicial emergencies. It focused on how to continue operations. It focused on the use and enhanced use of video conferencing technology. It provided surveys of applicable statutes and rules so we knew what the landscape would be. And that work was completed in 2009 and then updated in 2017. So that's the first thing we had going for us. We had to work pre-planning of that pandemic task force. The second thing that we had, which is not common amongst all the states, is we actually had a Judicial Emergency Act on the books. It's been on the books since 2004, and it was updated in 2011 following the work of the task force. We did see some legislative needs that needed to be addressed. The act was important because it kept us disciplined, as Justice Thomas urged us to be. It kept us disciplined and cabined in what we felt like our judicial powers were and were not during the midst of an emergency. And so we had a rules-based approach to how we responded to the challenges. And then the third thing that we had going for us was our judges and our court professionals and our lawyers across the state. I've said this often, our Constitution defines our judicial system as a unified court system, but that's the last time that word is used to describe our court system, because in reality, we're anything but. But now I have to add this caveat, until now. We are as unified now as a court system as we've ever been. As this challenge has galvanized us, we've been unified and as a team in meeting the challenges. All the various classes of court, the clerks of court, and bar leadership. In the midst of this process, I have found hundreds of new heroes and friends who I've seen step up to every challenge, just like Daryl Sutton has just done. Face real challenges and play team ball. I need to give special attention and recognition to my Supreme Court colleagues who have worked on our team and committed intense hours and innumerable hours to the efforts of planning and responding to this pandemic. Led first by Presiding Justice David Namias, Justice Michael Boggs, Justice Keith Blackwell, Justice Keith Peterson, our Clerk of Court, T. Barnes, y'all know Tia Melton, and our Public Information Officer, Jane Hanson. Without them, we would not have been able to do a fraction of what we've been able to do, not just as a court, but as a court system throughout the state. So those were the advantages that we had going in, and then the pandemic hit. In the first week or so in March, there was real fear spreading throughout the state and the courthouses across the state. And I have to tell you that when a virus hits your building, that fear is real. There's fear for the safety of the individuals. There's fear for the safety of your family. And there's a real tendency to want to just shut down operations altogether, go home and shelter hard in place. In March 12th, we worked with Judge LaGrua, the president of the Council of Superior Court Judges at the time, and Judge Brasher, Chief Judge of Fulton County. And we finalized a model local order to address the pandemic situations to where they would not shut down, but adjust operations to remain safe. Those were distributed on that day, March 12th. On March 13th, on a Friday, those orders began to be executed by the chief judges in those circuits and began to be sent into our court. On that same day, Friday, the governor declared a statewide emergency. The next day, on Saturday, our team worked and prepared a statewide judicial emergency declaration, which was issued on that day. On March 16th, we had our first emergency meeting of the Judicial Council, and we've been meeting weekly, almost weekly, ever since. The big picture has been to be safe, be safe, be safe. But also, we need to keep operating. Our court system is critical to the balance of power, to the structured discipline of resolution of disputes. And we have to keep operating because only the courts can do what we can do, and critical needs have to be met. So while we're operating, we reduced operations to those which were critical and the core functions of our court system. But ever since that time, we've been building up services as we figured out how to do so, as we've settled in, as we perfected the tools, as we got better at video conferencing, as we've changed rules to expand the use of various tools. We've been adding back services to do more. We have backlogs that are piling up. We have to keep those to a minimum. We have to reduce those, but we also have to remember what we call the DBJ principle. That is, don't be a jerk. As we work hard to move cases, we still have to accommodate one another. And I believe our lawyers all across the state have been doing that. We've been extending our declaration every 30 days since then. The last extension was issued yesterday afternoon. The guts, the terms of what that extension calls for is essentially the same as the past order. But what the existing order does do, in addition to maintain the previous order's terms, is it lays out the plan for going green on July 14. It lays out the plan for opening up expanded operations on July 14. We anticipate that we will expand services and maintain the ban on jury trials, largely because we still have to be careful. We have to be careful, and we're taking a slower pace because when we call people into court, we compel their attendance. People do not come to court because they volunteer to do so. Lawyers are called in because their cases are on the calendar. We compel witnesses, we have subpoenas, we have jury summons. We have to be careful when we make people show up. We'll have to see about grand jury proceedings and what we'll do from there, but we expect things to go forward much more so beginning on July 14. We also created a COVID-19 task force that's chaired by Superior Court Judge Sean LaGrua. It includes representatives from the various classes of court and other stakeholders, including the state bar, prosecutors, public defenders, civil plaintiffs lawyers and defense attorneys, and the clerk of court, the sheriffs, and other members of the public. Their mission is to figure out what our operations will look like as we move forward, what our post-pandemic courts will look like. They've already begun working on a bench guide that will be done and published in the next few days. One of the byproducts of this pandemic is a budget crisis. In response to the budget crisis, the legislative leadership and the governor have instructed the court system, as well as everybody else, to submit budgets for 2021 with a 14% projected cut. For our court, 14% reduction looks like this. It would call for 19 furlough days for all employees, including the justices. Even though justice can't be furloughed, we have agreed to voluntarily participate, plus other significant cuts. And so that's what it looks like for us. You should know that it looks similarly for all aspects of the judicial system, maybe in different ways, but as severe for every entity within the judicial system. We are somewhat encouraged that the revenues coming in look like a 11% reduction as opposed to a 14%, and maybe even more like a 10%. But at this point, every 1% reduction is very welcome. We appreciate that this budget crisis is real. Judges have been prepared and are prepared to work harder with less. We do need, though, to be able to perform our constitutional duties, and we need to do so at a high level. We've been impressed that the legislative leadership has been sensitive to that message. We're also thankful for bar leadership speaking into that issue and supporting us in that regard. And let me say this about bar leadership. Bar leadership has been outstanding. Of course, you know that. They've helped create a temporary rule to expand the use of video CLE. You have helped to provide provisional licenses for law students graduating from law school so they can practice law while they're waiting for the delayed bar exam. You've worked with the governor's office to enable notaries to conduct their functions virtually. You've had rank and file folks like James, who stood watch and protected the state bar, but was humble and didn't want his name shared out to the public. I want to thank Darrell Sutton, especially for his exemplary leadership. He's risen to every challenge, whether it's the pandemic or the budget or just life in our country. He's been calm, he's been thorough, he's been systematic, he's been collaborative, and he's been humble. I want to congratulate my good friend, Don Jones. I'm excited. I'm excited for the opportunity to work so closely with you. You were an early friend when I came to the court, and we have grown together, and it's a joy to think that we have the opportunity to co-serve during this next coming year. As Daryl mentioned, we do have challenges. And as we look out and face those challenges, we could easily become cynical. But I'm confident. I'm confident because my ability to be cynical is limited. It's limited by the great experiences that I've had. It's limited by the reality of how my colleagues on my court have treated me. It's limited because I look at how you have treated me. I look at how you treat each other. I look at how you engage with your public and how you see your role in your communities and how you rise to this challenge and see your role as expanding your circle of influence in a meaningful way. You are all role models, and you make me proud. I am proud to be a judge, and I'm proud to be a Georgia lawyer. Thank you.